Good evening, everybody. I'm calling to order the Dartmouth Conservation Commission's public meeting of Tuesday, March 25, 2025. We do have a quorum of commissioners present. There are five commissioners present, so all votes will require an affirmative vote of at least four to pass. We're conducting this meeting tonight remotely as a result of legislation that Governor Healy signed on March 29, 2023, which further extended the remote hybrid option for municipalities, and that's extended until the end of this month, March 31, 2025. The public hearings do allow for live interaction. There's a raise your hand feature. You can wave your hand, and then we will allow you to speak. I will indicate that it might be best if you're not speaking to mute yourself so that your background noise doesn't interrupt somebody else's presentation. That being said, this meeting was duly posted at Town Hall and on our website, so it's being legally conducted after being posted properly and noticed properly. We're moving on now to our administrative portion of the meeting, and the first I would entertain is a motion to approve the minutes of February 25, 2025.
So moved.
Second.
We have a seconded motion on the floor. We'll have a roll call vote. Richard?
Yes.
Megan?
Yes.
James?
Yep.
Nat?
Yes.
My vote is yes. That motion passes unanimously. Our second administrative item I'll entertain is a motion to approve the field trip reports of the March 11, 2025 public meeting.
So moved.
Second.
Seconded motion on the floor. Roll call vote. Richard?
Yes.
Megan?
Yes.
James?
Yes.
Nat?
Yes.
And my vote is yes. That motion passes unanimously. The final administrative item is to receive the minutes for March 11, 2025. May I have a motion to that effect?
So moved.
So moved.
A second,
Second.
please. Seconded motion on the floor. Roll call vote. Richard?
Yes.
Megan?
Yes.
James?
Yes.
Nat?
Yes.
And my vote is yes. That motion passes unanimously. We have one field trip report this evening, and the field trip report is a request for a partial certificate of compliance on DEP file 15-2558. That's RCC 25-4. It's from Amber Dos Santos, PR Carl Rose, to segregate and release map 68 lot 3, otherwise known as 530 Faunce Corner Road, from the encumbrance of the currently open and extended order of conditions. Mark, what is staff's recommendation on this request?
Well, a little background, we issued an order of conditions for two abutting lots, 508 and 530 Faunce Corner Road, both lots under separate ownership. Mr. Rose, the owner of 530 Faunce Corner Road, I believe has since passed, and his daughter is acting as his representative and wants to sell that property, but the property is encumbered by the singular order of conditions for the both lots. Therefore, she has requested of the commission through CEC to get a partial certificate of compliance, which segregates that lot out independently from the combined lots under the order of conditions. The work has been done in accordance with the plan. It was just maintaining some ditch work throughout both sites, and staff's recommendation is to issue a partial certificate of compliance solely on lot 530 solely at the address of 530 Faunce Corner Road.
I got a quick question. Is the work completed on the other lot or is it still to be done?
Yeah, so it was done years ago. I don't know, the other lot is owned by, Mr. Rahim Agai. We know him, in town. I don't know why he's not done anything with it. I have not spoken to him about it. This request came from the Rose family, and Mr. Rose's name is on the order. Mr. Rose signed Mr. Rose's name is on the notice of intent. Mr. Rose's signature is on the notice of intent, and Mr. Rose was named as part of the order of conditions.
Okay. Well, I don't have a problem with that. I just was curious as to why the other lot wasn't being released as well, but nobody asked for it. We don't release it, I guess. Any commissioners have any questions? I don't see any. I'll entertain a motion to issue a partial order of conditions segregating lot number 3 on map 68 from the other lot that was in the order of conditions, and to give a certificate of compliance on lot number 3, map 68 only.
So moved.
Second.
We have a seconded motion on the floor. Roll call vote. Richard,
Yes.
Megan,
yes,
James,
Yes.
Nat.
Yes.
My vote is yes. That motion passes unanimously. We have a number of public hearings this evening. The first one is a continued public hearing, DEP file 15-2775, NOI 25-11. It's on the notice of intent for Michael Ferry and Jessica Schmitz to construct a swimming pool, tennis court, and driveway at an existing dwelling and within the 100-foot buffer zone to a bordering vegetated wetland in land subject to coastal storm flowage. The applicable regulations are 310 CMR 10.02, 10.55, and section 360-2. The land is described as map 113, lots 33 and 35-1, excuse me. It's otherwise known as 6 and 8 High Street. I'll entertain a motion to waive the reading.
So moved.
Second.
We have a seconded motion on the floor. Roll call vote. Richard,
Yes.
Megan,
yes,
James,
Yes.
Nat.
Yes.
My vote is yes. That motion passes unanimously. Is Rich Rayum here on behalf of the applicant?
Yes, I am.
You've got the floor, Rich.
Okay, last time the hearing was opened, then there was concern by the abutters and the commission on the drainage, the visual that the tennis court would have, and the noise. And so we continued the hearing, we modified the plans. We at first proposed a soundproof wall, basically acoustic wall between the Greens property and the court. And Mrs. Green had discussions with Barbara Ferry and said she didn't want an acoustic wall, that she really wanted plantings designed by Simpson, the landscape architect firm. So we submitted a revised plan that shifted the tennis courts slightly away from the greens, enough to get them out of the buffer zone of the vegetated, bordering vegetated wetlands. So the only jurisdiction is land subject to coastal storm flowage. The bottom right corner of the court still falls in the floodplain of the 100-year flood. And the performance standard for that is basically to have stable ground. So certainly having stable ground. We showed drainage intercepted from the court because the added drainage was a concern. of flowing onto the Greens property. So we've conveyed that to a dry well that's far to the south, south being on the right side of the field. And you can see the arrows flowing down towards the water. That basically goes to the wetlands, which runs to the ocean. So none of the drainage will come onto the Greens property. They'll actually find a decrease in peak rate of runoff and a decrease in the volume. We added notes that the Ferrises have committed to not allowing the court to be converted to a pickleball court, and that the permit is being granted based on the field not being artificially illuminated at night. Then Stimson did do a detailed drawing that has both evergreen trees and evergreen shrubs that are planted between the court and where the Greens intend to build their house. And they gave some renderings to show what the court would look like. And if we can bring up one of those renderings, it's from inside the court, just to see how the bottom of the court's actually going to be a wood paneled fence, and then the wood posts are going to go above that 4-foot level with chain link fencing. It'd be black coated so that you really don't see it. And this is the view that the Greens would have from their property. It'd be a dense planting of shrubs and trees. And then finally, a recommendation from conservation staff is that we have the lower 6 inches of the tennis court fence be raised off the ground so little critters can run across the court. But that's really not practical in a tennis court, because balls tend to be rolling and would roll under the fence into that dense planting of evergreen trees, never to be seen again. So we're asking that recommendation be withdrawn. That's the end of the presentation. Joe Waller from Stimson Associates is online, so he can be queried on anything the commission has to ask about the plantings.
Thank you, Richard. It seems like you've and your clients have had listened carefully and tried to accommodate some of the issues that were brought out at the last public hearing. Mark, I would be interested to hear staff's comments on this revised plan.
I will comment in a minute. I didn't realize until late today that Eduardo was going to be here sitting in. So since he handled this hearing last time, I would yield to him if he has any comments before I make mine.
I have no comments. I've already talked to Mark about this particular piece.
Okay, having said that, I concur with what you just said, Mike, based on what I read in the minutes and the discussions I had with Eduardo relative to the the last hearing. I acknowledge the letter that was written by Prime Engineering addressing each and every comment. I am prepared to recommend a standard order of conditions in accordance with the proposed improvement plan and landscaping plans dated March 19th, 2025, with one addition. And I acknowledge to Rich, I didn't even think about it at the time, but actually we can drop the screen share. I didn't even think about the practicalities related to tennis courts. My daughter played tennis for many years. I said, gee, why did I think of that? So what I've done is I've adjusted that comment or that condition. And I rephrased it to say, aside from the fencing around the proposed tennis courts, any future fencing within conservation jurisdiction shall allow a bottom gap of 4 to 6 inches to allow for wildlife passage. So if other fencing goes up on the site in our jurisdiction, I'd appreciate having that gapping. But in terms of the practicality around a tennis court, I agree, having that gap is pretty much impractical. So standard order of conditions with the addition of that one additional condition.
Thank you, Mark. Does any commissioner have any questions either of Mr. Rayum or the landscape architect who's online, or staff?
Mr. Chair, may I be heard?
Yes.
I couldn't see it too well. I apologize for that, but I'm sure it could be answered. Will the shrubbery around the tennis court also be on the eastern side? That would be between, I think, Dr. Walker's property and Mr. Manley's property, or is it only going to be on the western side as it relates to the greens?
The plans currently just show it on that western side. There's quite a bit of distance on the eastern side from their dwelling in that area. If it becomes visually offensive, I'm sure the Ferries would be willing to plant some evergreen screening, so the abutter couldn't see it in the distance.
All right, and thank you. You did address the issues that we had discussed last week vis-a-vis the lights. That's been taken care of, and also there is a statement that there will be no pickleball playing or pickleball design of the court and then pickleball playing. And I'm sure you won't have any objection of that being put into the conditions. Am I right?
That's correct.
Okay.
Richard, just for the record, it's a note that on the plan of record.
Yeah.
Excuse, you got it.
So
Thank
it'll
you.
be,
Okay,
it's already on the plan of record.
you got it. Thank you.
Does any other commissioner have any questions? Is there anyone in the audience this evening that wants to be heard on this application? I don't see anybody. At this juncture, then, I'll entertain a motion to close the public hearing.
So move.
Second.
We have a seconded motion. Roll call vote. Richard?
Yes.
Megan?
Yes.
James?
Yes.
Nat?
Yes.
My vote is yes. That motion passes unanimously. I'll now entertain a motion to issue a standard order of conditions in accordance with the proposed improvement plan dated March 19, 2025, with one addition to include a condition that says, aside from the fencing around the proposed tennis courts, any future fencing within conservation jurisdiction shall allow a bottom gap of 4 to 6 inches to allow for wildlife passage. They have a motion to that.
So moved.
So moved.
Second.
Second on that motion?
Point of order,
Yeah.
Mr. Chairman. We should also include the landscape plan as part of the plan of record.
Did they have an, all right. So
I didn't write it in my note, but it should be in there.
is it just called a landscape plan? Is there any title to it?
I believe it's just a planting plan. Is that true, Mr. Waller?
That's correct. Yes, it's called planting plan.
Okay, so
And
I will
what's the
amend
date
that.
on that, Mr. Waller? I want to make sure I got it right.
The date is January 21st, 2025 on the drawing.
Okay, I'll amend my proposed motion there to include, in addition to the proposed improvement plan, to include the planting plan. And that was January, what was the date on that?
January 21st, 2025.
January 21, 2025. So I'll include the planting plan along with the proposed improvement plan in the motion.
So
We have
moved.
that. And a second on that,
Second.
please.
Second.
We have a seconded motion. We'll have a roll call vote. Richard,
Yes.
Megan,
Yes.
James,
Yes.
Nat.
Yes.
My vote is yes. That motion passes unanimously. Mr. Rayum, thank you very much, and thank your clients for being attentive to the concerns of their neighbors.
Okay, thank you.
Second public hearing is a continued public hearing, DEP file 50-2763, NOI 24-53. It's on the notice of intent from Carl M. Furman for the proposed demolition of a single-family residence and soil absorption system and the reconstruction of a new single-family residence, soil absorption system, utilities, and site work on a barrier beach, coastal dune, both within land subject to coastal storm flowage and within the 100-foot buffer zone to a salt marsh. The applicable regs are 310 CMR, 10.02, 10.04, 10.27, 10.28, 10.29, 10.32, and section 360-2 of the bylaw. It's on land described as map 87, lot 20. It's otherwise known as 13 Smith Avenue. May I please have a motion to waive the reading?
So moved.
Second.
A seconded motion, roll call vote. Richard,
Yes.
Megan,
Yes.
James,
Yes.
Nat?
Yes.
My vote is yes as well. That motion passes unanimously. Commissioners, we had a email request from the applicant's engineer asking for us to continue this public hearing until April 8th, 2025. And I'll let Mark explain the reason why they want it.
Before I do the explanation, I have had this conversation with the chairman. I have issued a disclosure statement to the town clerk and to Human Resources regarding this particular project. Until recently, I was unaware, but the Furmans had retained a company by the name of Race Coastal Engineering out of Connecticut. I know Race very well. In my previous life as a consultant, I did quite a bit of environmental work as a subcontractor to Race. That has been probably 15 years ago since the last time I worked with them. I know personnel there. I do not believe that there is a conflict of interest. However, certain individuals might assume that there is an appearance of conflict of interest. Because of that, I have written a disclosure statement indicating that my previous relationship with Race Engineering will have no effect on how I review this particular project. Again, that's been submitted to the town clerk and to Human Resources to go into my personnel file.
I want to let the commissioners know that I did speak with Mark, as he mentioned, about this. I agree with his assessment that it be disclosed, but it is my opinion this is not a conflict of interest. He is not currently receiving any work from Race or engaged in any consultations with Race, doesn't anticipate any in the future, and the last business relations, as he alluded to, were well over a decade ago. So yeah, I think the disclosure was appropriate, but I do not believe it's a conflict of interest.
I should also add that I did reach out to Race yesterday when I found out that they were involved in this project. I spoke to their president and I explained the situation to him, and he was very comfortable with my disclosure. He appreciated it, and he appreciated that I reached out to him. And I had not seen Mr. Santa, like I said, in over over a decade, probably closer to 15 years. So having said that, I wanted to put that on the record and in the minutes for the public record, in case anybody questions that. I am aware of the situation, and taking appropriate action. Now to the cause for the request. Because of Race's involvement and some other consultants who have been involved, the plans were revised. We did not get them on time. This is a project that really needs to take some scrutiny, and I think this has been a protracted project. This was first applied to us in December of 2024, and we have continued it several times. And normally I would not, be so inclined to support another continuance after 3 or 4 of these. However, I do think in this case it is prudent, given the fact that the plan has drastically changed and the narrative has, I believe, has drastically changed. I haven't exactly read it, to address some of the significant concerns of not only your staff, myself and Eduardo, but also DEP Lakeville. So my recommendation is to continue until April 8th.
Thank you, Mark. Does any commissioner have a question regarding the request for continuance? Is there anyone in the audience this evening that wants to be heard tonight on this matter? I don't see any. So commissioners, at this point, I would entertain a motion to continue this public hearing until April 8th, 2025 at 7 p.m.
So moved.
Second.
Second.
We have a seconded motion on the floor. Roll call vote. Richard?
Yes.
Megan?
Yes.
James?
Yes.
Nat?
Yes.
My vote is yes. That motion passes unanimously. That moves us on to the third public hearing, which is a continued public hearing, DEP file 15-2776, NOI 25-12. It's on the notice of intent from Peter and Deborah Gates for the removal of invasive vegetation by hand. It's within the 100-foot buffer zone to a bordering vegetated wetland. The applicable regulations are 310 CMR 10.02, 10.04, 10.27, 10.28, 10.29, 10.32, and section 360-2 of our bylaw. There's also a parenthetical, I think it's just a repeat in the parenthetical on the, and maybe not.
Yes, it is. I'm sorry.
Okay. I just want to
No,
make sure.
actually, no.
No, it isn't. We got 10.55.
Yeah, but actually, I would request that you recite the applicable things. Forget the first parenthetical. It's only the second. I didn't pick up on that. That first parenthetical should have been deleted. So it should be 310 CMR 10.02, 10.55, and section 360-2.
Got it. So our applicable regulations are the second parenthetical, not the first. The first should be deleted. So the second reads 310 CMR 10.02, 10.55, and section 360-2 of our bylaws. It's on land described as map 102, lot 10. It's otherwise known as 16 Shore Acres Road. I'll entertain a motion to waive reading at this point.
Moved.
Second.
We have a seconded motion on the floor. Roll call vote. Richard?
Yes.
Megan?
Yes.
James?
Yes.
Nat?
Yes.
My vote is yes. That motion passes unanimously. I guess, Richard, you got the floor again.
Yep. So, again, this had been open previously, and Mark had noted correctly that the plans had a paucity of details in terms of how the invasives were going to be removed and what was going to end up being there after the invasives were removed. So we've modified the plan. In the upper left-hand corner, added a lot of detail about how the stuff was going to be removed by hand with no brush hogs allowed, and that if there are areas of 100 square feet that don't have trees or shrubs, in other words, once the invasive plant was removed, there was nothing in that area and no trees, then there would be plantings of suitable habitat-friendly vegetation, such as blueberry, which provide food source and shelter for birds and the like. We noted that the edge of lawn, which just looked like a squiggly line on there, had in fact been located by our survey crew and represented the true edge of lawn. And then we gave the square footage of the area that is going to be having invasive removed, no trespass into the wetlands. And as I said, if there are plenty of indigenous shrubs left, the ground would be left that way. If it ends up having big open areas, we'll replant those areas. And that's about the presentation.
Thank you, Richard. Mark, I'd like to hear staff's comments on this request, please.
Again, I would yield to Eduardo first, if he had any comments, because he was involved with the first session of the hearing.
My only comments are essentially what Mark has already discussed, that the previous plans were a bit vague in terms of.
Eduardo, I'm having trouble hearing you. I'm not sure if everybody else is.
It's very light, I mean, very low. So yeah, I agree with you, but I understand. I heard him, but it was very hard to hear.
Oh, okay. I'll just try to speak a little bit louder. Essentially, I'm just going off what Mark was saying. So the previous plan was a bit sparse in terms of details, but it seems as though this plan has improved. And those are basically just my comments.
I think those were his comments.
Again, it was garbled to me. I don't know if you heard it, but I'll take it from here. Here again, staff acknowledges the comments made in the letter from Prime Engineering to the commission. And they did address pretty much everything that I had commented on regarding getting the plan a little bit more true to existing ground conditions and giving us a little bit more detail on the hows and the wheres of how this work was going to be done. So staff is in the position to recommend the issuance of a standard order of conditions in accordance with the proposed invasive plant control plan, which is what we're looking at right now, dated March 19th, with 2 additional conditions. The first one being a conservation agent should be present to review and corroborate the identification of the invasive species to be removed prior to their removal, and to also approve any native species replanting program if and where necessary. The second condition is the removal of any erosion control devices shall only occur when approved by the Conservation Commission or staff.
Thank you, Mark. Does any commissioner have any questions of either Mr. Rayum or of staff? I don't see any. Is there anyone in the audience this evening that wants to be heard on this application? I don't see any. I'll entertain a motion to close the public hearing.
So moved.
Second.
We have a seconded motion on the floor. Roll call vote. Richard,
Yes.
Megan,
yes,
James,
Yes.
Nat?
Yes.
My vote is yes. That motion passes unanimously. I'll now entertain a motion to issue a standard order of conditions in accordance with the proposed invasive plant control plan dated March 19, 2025, with 2 additional conditions. The first is that a conservation agent should be present to review and corroborate the identification of the invasive species to be removed prior to their removal, and to also approve of any native species replanting program if and where necessary. The second is the removal of any erosion control devices shall only occur when approved by the Conservation Commission or staff.
So moved.
Second.
Second.
We have a seconded motion on the floor. Roll call vote. Richard,
Yes.
Megan,
yes,
James,
Yes.
Nat?
Yes.
My vote is yes. That motion passes unanimously.
Thank you very much.
Thank you and good evening, Richard. Our 5th public hearing is I'm sorry, I should go to the 4th one first. Would have been helpful. It's a public hearing on EP file 15-2780, NOI 25-13. It's on a notice of intent from Joseph Tattlebaum, care of David DeVignan, to reconstruct the northern stone jetty within land subject to coastal storm flowage. It's over previously disturbed coastal beach, coastal bank, land under the ocean, and land containing shellfish resources. And it's within the 100-foot buffer zone to a coastal bank. The regulations are 310 CMR 10.02, 10.04, 10.25, 10.27, 10.30, 10.34, and section 360-2 of the bylaws. It's on land described as map 124, lots 8 and 13. It's otherwise known as 31 Mosier Street. I'll entertain a motion to waive the reading, please.
So moved.
Second.
We have a seconded motion on the floor. Roll call vote. Richard,
Yes.
Megan,
yes,
James? Okay, we'll skip
Yep.
Jim. Oh, there you go. Nat?
Yes.
My vote is yes. That motion passes unanimously. We have gotten a request from the applicant on this matter. They wanted to continue this until April the 8th. But before we take that motion up, Mark, do you want to have any comments on this request?
My only comment is that they submitted information to us after the revision deadline. This is the first request for a continuance on their part, so I see no reason why we shouldn't grant it.
Very good. Does any commissioner have any questions? Is there anyone in the audience that wants to be heard on this particular application this evening? I don't see any. So I'll entertain a motion to continue this public hearing at the applicant's request until April 8, 2025 at 7 p.m.
So
So
moved.
moved.
Second,
Second.
please. We have a seconded motion on the floor. Roll call vote. Richard,
Yes.
Megan,
yes,
James,
Yes.
Nat?
Yes.
And my vote is yes. That motion passes unanimously. Now we can go to the 5th public hearing. It's a public hearing, DEP file 15-2781, NOI 2514. It's on the notice of intent from Paul Bourgeois to construct a single-family house with associated driveway, utilities, grading, and landscaping within the 100-foot buffer zone to a bordering vegetated wetland. The regulations are 310 CMR 10.02, 10.04, and 10.55, as well as section 360-2 of the bylaw. The land is described as map 165, Lot 42. It's otherwise known as 80 Slade Street. I'll entertain a motion to waive the reading, please.
So moved.
Second.
We have a seconded motion on the floor. Roll call vote. Richard,
Yes.
Megan,
yes,
James,
Yes.
Nat.
Yes.
My vote is yes. That motion passes unanimously. We had gotten an email from the applicant seeking a continuance, and I was told before this meeting by Mark that the application, or the continuance rather, they would seek is until our April 8th meeting, April 8th, 2025 at 7 p.m. But Mark, before we take that motion up, do you want to make any comments on this request?
Yes, I do. This is a request to develop an A&R lot in the area of Slade Street, and it actually would be on the paper street, Philbrook Street. The applicant is proposing the appropriate improvements to meet proper accessibility requirements to make this a buildable lot. What is interesting about this particular project, and I have to commend the applicants, they have been very, very cooperative in this, is this lot and the abutting Philbrook Street, which is a paper street, are subject to an enforcement order, not of the fault of the owner or applicant of this particular project, but certainly on their land, as part of the 28,000 plus square foot of wetland impact at 51R Slade Street, which is across the paper street. I received today a draft plan from the applicant for my pre-application review with a complete restoration of approximately 2,650 square feet of the unauthorized impact caused by the abutter. And I want to applaud the applicant for that effort, because I realize that for them to, be made whole on this, they would have to, deal with the abutter. Having said that, they need to restore this as part of their program moving forward, and they have been very willing and very accommodating. Having said that, I wholeheartedly recommend that we issue the continuance until the 8th, so that they can finalize the plans and get them in, and it will begin. They certainly will benefit by being able to do their project, which seems to be a very appropriate project in the area. And we will also begin to whittle away at a very, very intense wetland violation. Not of the applicant's doing, but certainly the applicant being victim of.
Mark, thank you for that explanation. Does any commissioner have any questions regarding this request for continuance? Is there anyone out in the audience this evening that wants to be heard on this particular matter this evening? Again, I don't see anybody. So commissioners, I'll entertain a motion to continue this public hearing as requested by the applicant until our April 8th, 2025 meeting at 7 p.m.
So moved.
Second.
We have a seconded motion on the floor. Roll call vote. Richard,
Yes.
Megan,
yes,
James,
Yes.
my vote is yes. That motion passes unanimously.
Mr. Chair, I don't believe I voted on that last one, so I vote yes.
Oh. Okay, I'm sorry. I skipped you. I'm sorry.
Either that or I missed it, but it's fine. We got it.
Okay, I try to remember these things. I apologize, but it was unanimous now. So sorry about that.
No
We've
problem.
now concluded the public hearing portion. We're going to items for discussion. So Mark, I'll turn the mic over to you. You've got the items for discussion. We have no bills.
Okay. First off, there are no bills. Secondly, under discussion items, we have a few. The first one is the emergency response request at 132 Woodcock Road. I emailed the commission about a week and a half ago, give or take. The engineer had come in requesting an emergency action. And under the bylaw, either the commission or a duly authorized individual, I would believe that I qualify for the latter,
I think so.
can issue an emergency action response. This is a septic system to a single-family home, which houses, I believe, a half dozen plus or minus into disabled individuals who need care and have some severe disabilities requiring an intense use of the laundry, and the septic system is failing. This has been corroborated not only by our staff, but by the Board of Health staff. The applicant, through their engineer, South Coast Engineering, Greg Nicholas, requested both of us and of the Board of Health emergency response action. I had indicated early on, since there are down gradient wetlands which discharge into the Slocum River watershed, a watershed that has a TMDL for bacteria and nitrogen loading, that this was a very prudent practice given the fact that there is evidence of fresh breakout coming out of the leaching field. I made that decision. I issued it to you, giving my rationale and suggesting any opposition by the commission I would certainly respect. I heard none, so I'm assuming that was okay to move forward. The second part of that was we would move forward only if the Board of Health agreed that it was an emergency situation, given the fact that it's a septic system and it's a Title V issue. Public Health Director Michaud polled his board, and they unanimously approved the emergency response under Title V. So I concur, they told me that, and I concurred with Greg that my emergency response authorization was in fact satisfied, move forward. Now, under our regs, they have 45 days to file on an emergency action. We have already received, literally 2 days after the first conversation, we have an RDA in front of us, so we will be hearing that next week. So they will be in full compliance should we grant a negative determination, which I think we will, based on past experiences. So that is where we stand on that. Again, that's 132 Woodcock Road. Any questions from anybody? That was a mouthful in a short amount of time.
Nope.
Okay. Second piece of information, I'm going to give you an update on the open meeting legislation. As of last Thursday, the House and the Senate voted to authorize a continuation of hybrid and remote meeting through June 30th, 2027. That legislation has been moved to the governor's desk. The governor has yet to sign it. She's only got 6 days before the issue runs out. So we are a bit tepid because our next hearing, we're not sure whether it's in person or not. My guess is it's not, given the fact that the governor had previously written some legislation or some executive order to allow for hybrid and open meeting and remote meetings to continue. She wasn't really, I don't know what the time frame was on hers, but I believe she's going to sign this. So I think we'll be able to continue as we are until June 30th of 2027. However, I would put a little asterisk on that. We still don't have the governor's signature on that, but that's where it seems to be trending at this point. So that's just an FYI for you folks.
Mark, I believe that it will be signed tomorrow before 4 o'clock.
Okay, that'd be great. I just want to, it would just be great if we got it behind us. You know, it's, right now, we're holding up a lot of paperwork because we don't quite know what to say. You know, we have a draft agenda written. I got to change the clause at the top of it. I also have to get Zoom links, which I haven't yet done because we don't know, but that's good news if that's what's happening. Thank you,
Don't
Richard.
shoot me, Mark, don't shoot me if she doesn't, but I was told that it would be signed tomorrow by 4. But
Okay.
government is government, isn't it?
Yeah, well, they rode the South Coast Rail yesterday. She was busy.
That's because it was free for the month of March.
Anyway, okay, so that's the update on the open meeting. Third, just this is an FYI, I'm putting you on notice that the site at 498 Old Westport Road, the old Pine Hill site, I think some of the older members might be familiar with this.
Yep.
There is a 40B comprehensive permit application coming to the town on this for, I believe it's 5 or 6 multifamily buildings on the front portion of that site. I saw a draft plan and there is some, based on their wetland line, there is some infringement on buffer zone. Most of the property, and when I say most, I'm going to say 85% of it is wetlands to the rear. The only portion they're proposing to use was the active gravel pit area, which abuts Old Westport Road. And for those who don't know where this site is, it's the big vacant site, sort of near Dartmouth Orchards and Lucy Little Road, just a little west of Lucy Little Road, on Old Westport on the north side. There are extensive wetlands and extensive surface water. I believe there are vernal pools out there. The project work is not near those things, but only in the buffer zones to some of the wetlands and the waters. What is interesting, and I think it's important for us to know, 40B projects, comprehensive permits, sort of negate a lot of local bylaw control on development projects because they're designed for affordable housing. However, one of the laws which is not affected is the Wetlands Protection Act. So they still need to come before us if they are within our jurisdiction, regardless of whether they're a 40B or not. The only thing that can be affected is if the applicant requests of the Zoning Board of Appeals to waive the wetland bylaw, which the ZBA can do. And if that's the case, then our jurisdiction is limited only to the Wetlands Protection Act. If they don't waive it, then they're subject to both the act and the bylaw. Just making you aware, we are very aware of this. Because we are having some issues with another 40B in town, so staff is kind of really trying to be ahead of this one as much as we can. There was supposed to be a site visit tomorrow. That has been postponed until April 1st. I or Eduardo will be attending that meeting. This one's going to be a little feisty. If anybody knows the neighborhood, they're not real big on these projects, especially these big projects. So just, again, beware.
Are they anticipating they're going to have, subsurface sanitation system? Are they intending to try to connect up to a sewer? What are they going to do?
I can't answer that right now, Mike. I don't know. I don't know that specifically.
Because I know from experience with DPW, currently, if you wanted connect up to the town sewer, you have to pay for on your own a comprehensive study uh, of the connection, including all the lines leading back to the treatment plant, to make sure that there's adequate capacity for what you propose. And if not, you have to upgrade everything all the way to the treatment plant. And
Yeah, again, that,
40B doesn't let you get past that.
pardon?
40B won't let you get past that either.
Yeah, again, we are in the early stages of this. We have not had an official discussion amongst, town boards, town staff on this, so, I can't answer that question offhand.
Okay. Well,
All right.
unfair to ask it. I just thought if you knew.
No, I don't, but Crispy Show is certainly involved in this, and so is Tim Barber, so, we'll figure it out on our end, and I will
Two competent
you-
guys, they do know what they're doing, believe me. And I'm sure they know the right answer between the two of them.
So I will keep you apprised of anything in a pre-app mode, but at some point, I certainly believe if this moves forward, they will be before us with a notice of intent. And it may come sooner than we think, so just be aware. The last item, I sent out a prospectus from UMass, who has been doing a research project for a couple of years in the town forest, which is non-conservation land. The brief is that they're trying to assess if noise from Interstate Route 195 has an effect on the wildlife communities abutting and adjoining the highway right of way. I have not seen any information on or any data on their study. It's been ongoing for, like I said, a few years, and they wanted to expand their range of sites, and 3 of their sites are on land owned by the Conservation Commission, or by the town of Dartmouth, care and custody of the Conservation Commission, and they wanted our permission to do so. I think it's a good project. It's very non-invasive. You don't even know they're there unless you're there with them. I asked for a straw poll. I got 3 positives. I need 1 more approval. I'd like if we could take a vote on this tonight, so we have a vote of record, so that I can respond to the research team.
I'll entertain a motion to allow the UMass Dartmouth research team to conduct their non-invasive studies to determine the impact, if any, on wildlife of the noises from Route 195 on land within the stewardship of the Dartmouth Conservation Commission.
Second.
The seconded motion, roll call vote. Richard?
Yes.
Nat? I'm not going to forget you this time.
Yes.
Megan?
Yes.
James?
Yes.
And my vote is yes. So there it is. It's unanimous, Mark.
Thank you much. And nothing really significant on enforcement. We've had a couple of minor dust ups, but we have resolved them before they got too complicated. So moving forward.
Perfect. I have nothing that I want to bring to the table. So if any commissioner has anything they want to discuss.
Just one thing, I saw we got an application for our final spot in the commission.
We did.
Correct.
Thank you. I
Oh,
forgot.
yeah, I completely forgot to bring that up. Yeah.
Yeah, but this is somebody that I've known for quite a while. He's an attorney with offices in multiple locations, but including New Bedford. Jay Tallerman is his name. He used to work with KP Law, they're municipal lawyers. They represented, 250 plus communities in the Commonwealth. He's very well versed, not just in municipal law, but also, as I was explaining to Mark, um, issues involving conservation, conservation commissions. He had served on a conservation commission of his previous town. He's represented conservation commissions as town or city council. So I think he'll add an awful lot if he gets, gets our approval or our recommendation, and then gets the appointment by the select board. But I think I think this will be a really good addition to our commission, adding knowledge that I don't have for sure on the municipal law side of it, and processes and procedures that we should be following. I think he'll be a great help. So if anyone's interested, we're going to try to set up an interview like we normally do. And I think Mark probably conducted by Zoom, I imagine.
Yeah, what we typically do is we set up, every commissioner is invited. However, these usually happen during the day, so timing is a problem. So typically it's a subcommittee, any subset of the total membership, which is 6 right now. I will throw out 3 dates, and times available to meet. So the first question is anybody interested in participating in those interviews? I will certainly be a part of it. I believe, Mike, you will probably be a part of it,
I
right?
will be, absolutely. Although I know him already, I still want to be part of the process.
Count me in.
Yeah,
Okay,
provided the timing works out, I'll join as well. If it doesn't, I read through his resume. I agree with Mike's, comments. He seems more than qualified, has the right experience. I guess the one concern I might have, which we sometimes have with folks with his background, is, is there a potential for a large number of recusals given his work, or if there's not, then that's a positive. If there's, just something mindful of, I guess.
Yeah, that's a good question, Nat. And that's one of the issues that I want to bring up in the interview, because although he may not, does his firm anticipate they're going to be handling matters before us,
Right.
for clients?
Right.
But I think what they're really focused on, all of the attorneys in his office had, every one of them that I'm aware of has had municipal law experience, either as assistant city solicitors or town councils, or having worked at KP Law. So I think they're probably going to be trying to get some of the communities in the Southtown area, South Coast area, to use them instead of who they now have, because
Sure.
they've got an office right here. So they're not going to be paying for the transportation like they would with KP, which goes from the Boston office to New Bedford or whatever. There's an hour and a half that you're paying, and they're not doing anything for you. But I don't know that for a fact, but that's a great question. That's a great concern, rather. It's my one question, my big question.
Yeah, I mean, other than that, everything else I thought that I read looked like he'd be a good fit, and we certainly could use the 7th person. So I'm excited to proceed with him.
Yeah, it'd be nice to have a full complement again.
It would. Yeah.
okay, so I will, do we have any days that we want to think about?
Thursdays, Fridays are great for me. I'm pretty wide open Thursdays and Fridays, so I don't care whether it's morning or afternoon. On other days, I can still do it. Probably afternoon better than morning.
Thursdays are better for me at the moment.
Richard?
Thursday's not better. Hopefully in the afternoon.
Okay. All right, so I will put together an email sometime tomorrow, get it out to him. I did push his credentials forward to the town administrator's office, because the typical process is we do a preliminary, we give the select board a recommendation, they interview, and then they make a decision. And I outlined that to Mr. Tolman as to how Dartmouth does it, and he seems very interested, so I will work on that tomorrow.
Appreciate
Cool.
that.
Thank you.
Anything else? Thank you for bringing that up, Nat.
Yeah.
I was gonna, I don't know what I'm thinking about today. I guess I was thinking about my dinner, but so anyway, with that, I'll entertain a motion to adjourn.
So moved.
Second.
Second.
We have a seconded motion. Richard,
Yep, yes.
Megan,
Yes.
James,
Yes.
Nat,
Yes.
my vote is yes. Meeting adjourned. Thank you, everyone. Appreciate your participation tonight.